My colleague is on his feet, but the directions given was that the application was only limited to the two of us, IBC and ourselves, unless it's acting for IBC.
What's wrong with you? There is no...
Mr. Ahmednasir, you are appearing for the third respondent.
Yes, my lord, third respondent.
Yes, that would be the party who would be adversely affected.
Very well.
Yes.
Most adversely, my lord, if I may add. Yes, my lord, in opposing this application, we'll be doing under 4 headings. One is that the entire application before the court is not pleaded in the petition. It's not pleaded in the petition. Secondly, my lord, the right to information under Article 35 of the Constitution cannot be litigated in the Supreme Court during a petition under 140. The right to information under Article 35 cannot be litigated in a petition under 140. My lord, thirdly, we will be arguing and hope to persuade you that your decision of 28 August on scrutiny and verification was a decision made per incuriam, and this court should depart from that. Lastly, my lord, and this will be argued by my learned friend, Mr. Masharia, the applications or the prayers the petitioner is seeking are either impossible or impracticable or unnecessary. And my lord, as my learned friend, Mr. Mahat for IBC rightly argued, and I will come to that when I'm arguing the second point, there is the proper procedure for obtaining information under Article 35 is outside this court. It's not inside this court. But my lord, let me start with the first one. Are these prayers pleaded, my lord? Are they pleaded in the petition? And my lord...
Sorry, Mr. Ahmednasir, who else did you say is...
Yes, my learned friend, Mr. Masharia.
Is with you in...
I will give him part of my time.
Okay, okay.
Yes.
That's what I want to be sure.
Yes,
that you are sharing the 30 minutes.
Yes, my lord, we will share 30 minutes, yes. So, my lord, it's my submission that the prayers and all the issues raised in this petition are not pleaded, in the application are not pleaded in the petition. And my lord, my learned friend, when she is replying, will show you, for example, in paragraph 6, when she talks of Muranga, and she lists these 10 polling stations. Let her show you where those 10 polling stations are in the petition. When she talks of Garissa, my lord, is in 6B, and she lists about 17 polling stations, let her show you where those polling stations are pleaded. My lord, in prayer 8, for example, when she talks of all those constituencies in prayer 8, they are not pleaded, my lord. And we could not, when we didn't have an answer or an opportunity to answer those when we are replying to this petition. Similarly, my lord, paragraph 9, completely not pleaded. Paragraph 10, not pleaded. Paragraph 12, not pleaded. Paragraph 15, not pleaded. Paragraph 18, not pleaded, my lord. So, and my lord, the mischief is very clear, my lord, because a petition under 140 has certain time limits. The petitioner files the petition in a skeleton form, then brings an application like this to expand the perimeters of that petition. It's a complete abuse of process, my lord. And my lord, we have seen too many instances where a petition that is dead on filing is suddenly kickstarted or gets a new lease of life through an application for the right to information, my lord. I think the example is fairly obvious. So, my lord, there are a lot of authorities, my lord, but I don't want to take your time on this. There is a supplement, there is a list of authorities, my lord, 6 authorities from the High Court and the Court of Appeal, which states that a party who does not plead a certain facts or law cannot raise that in a subsequent application or during the trial of the same. My lord, let me go to the second one, or the second ground, my lord. Before I go that, my lord, the bar you set, my lord, in the 1st September decision is fairly low, my lord. When a party makes this application and the court grants those prayers, if the first and second respondents don't obey those orders or don't comply, the test you have set now is that you will make an adverse inference, my lord, and you will nullify the presidential election. So, my lord, because of that, the court has to relook into that, and I think we will talk it at another time, that those issues must be pleaded so that all the parties know that this is the case they face during the trial. It should not come midstream during the trial. My lord, the second point is that can this court, my lord, in a petition under 140, do what is the exclusive preserve of the High Court, my lord? And my lord, I think my lord Justice Lenola will tell you, because he has been sitting as the inaugural judge of the Constitutional Court, that Article 23 of the Constitution gives the High Court exclusive monopoly for any litigation under the Bill of Rights. No other court, my lord. The Court of Appeal can do or can hear it if there is an appeal from the High Court, and this court, my lord, and my ladies, can do it if there is an appeal. But, my lord, can this court, in an application like the one filed by the petitioner, make a litigation on a Bill of Rights, my lord? No, it can't, my lord. Let me read for you, my lord, what Article 23(1) says. It says the High Court has jurisdiction in accordance with Article 165 to hear and determine application for redress of denial, violation, or infringement of, or a threat to, a right or a fundamental right. So, my lord, the petition is now saying that they want to access certain information. They want to exercise their right to information. Under Article 23(1), it's only the High Court that can address that right when a person is denied and when a person is allowed. My lord, if you look at your decision on 28 August on this similar application, you will find that, my lord, you could not base that decision on a specific provision of the Constitution or a specific provision of the statute that allows this court to hear a Bill of Rights in the first instance. You are on more firm and solid ground when you are analyzing the law as it relates to scrutiny. Because, my lord, both the Election Act and the rules therein provide specifically for an election court to order a scrutiny, and an election court, my lord, include the Supreme Court. But, my lord, when you retire and you look at that ruling of 28, you will not find any provision in the law that allows this court to hear that matter in the first instance, my lord. And, my lord, I don't want to emphasize or even say it, but there are so many decisions of this court where this court has warned itself of the danger of encroaching into the jurisdiction of both the High Court and the Court of Appeal. And the other courts, my lord, respectively have avoided to encroach into your jurisdiction. So, my lord, the point we're making here is that
did that, they will face the wrath.
My lord, they are conscious of that. And that's why they have kept very far from your exclusive jurisdiction. But, my lord, both under 140 and Article 163 of the Constitution, my lord, you will not find powers donated to this court to hear an application that seeks the validation of a right under the Bill of Rights, my lord. But, my lord, there is one case I will just refer to you. It's a High Court decision. My lord, it's case number 4. If you look at the third respondent's list of authority, the case number 4 is Nelson Harvey and others versus the Inspector General of Police and 5 others. My lord, this case is a case where the petitioners filed a constitutional petition seeking to stop the DPP from prosecuting them in that suit. Yes, yes. So, my lord, in midstream, they brought an application under Article 35 of the Constitution in which they sought certain information on how the DPP reached certain decisions. And an objection was raised that in that petition that seeks to stop prosecution, you cannot open midstream another application or another right under the Bill of Rights, i.e. 35, and seek certain orders. We argued, my lord, of course it's not binding, but you will find very persuasive law that you cannot, in a suit you have filed, bring a fresh suit, even in the High Court. And my lord, when you retire, I will pray that you look into that. But my lord, this court has, said on so many occasions, including Bita Munya case, including Nadif Jama, and many other cases, that the function of scrutiny is not to provide evidence, new evidence, or it's not a fishing expedition. But my lord, in the Supreme Court now, it is common that when a party does not have enough evidence to win the case, he will file an application under Article 35 of the Constitution, and suddenly the petition assumes a totally different character. And that's why I was submitting, my lord, that if you look at your decision of 1st September, the entire petition, 99% of that petition, the 4-judge majority decision, was based on the finding during the ruling of the finding pursuant to the ruling of 28, my lord. 98%, my lord. In fact, my lord, that was a case that was entirely determined on the interlocutory application because it becomes so vital. And when we argued the petition subsequently, I mean, it was only the interpretation of Section 83 of the Evidence Act that was new to the petition. So, my lord, it's so important that a party who comes to this court when they file their petition should prove their case according to the 4 corners of that petition. The moment we open, we will have a court process driven. The court will take over. My lord, the court take over. The court actually refurbishes and renovates the petitioner's case and gives it more zest and life. And I think that's detrimental to the respondents. Actually, my lord, a successful application under Article 35 is a transplant of the petition. It gives it more energy, it gives it more organs. But my lord, my submission is that the petitioner should prove the case as they filed. My lord, for those reasons, it's my humble submission that your ruling of 28 August 2017 is, insofar as it relates to Article 35, was a decision issued per inquirium. And my lord, there is no harm in this court departing from the same. I pray and encourage and submit, my lord, that you so depart, because respectfully, my lord, I think that was bad law. The first part of it was good law when it comes to scrutiny, and it was a very good decision, my lord. But my lord, you will find that the later part, it hangs. It has no foundation, my lord. My lord, with that, I will invite my learned friend to show how the orders, despite my, in addition to my submission, actually, it's impossible, it's impracticable, and as shown by Mahad, very unnecessary. My lords, unless you have any information, that's my part of the submission. My lord, just one point. I'm sorry. I'm sorry, my lord. My apologies. My lord, just before I finish, I will just draw your attention to Raila 2013. Paragraphs 204, my lord, to 209. Very, very lucid pronunciation, very lucid, my lord, exposition on the powers of this court as an election court, my lord. The powers, the jurisdiction, the limit, my lord. My lord, just look at what you said in 206 and 207. And my lord, when the court retires and you look at 206 and 207, you will agree with my submission as your powers to adjudicate of appeal of rights. I'm most obliged.